This is TWiT.
The U.S. Supreme Court will be hearing initial oral arguments. And Leo, in your quick summary of the podcast, you properly named the first of the two cases.
Gonzalez versus Google. Yeah, I listened all morning. It went on and on and on and on and on and on and on.
Yeah, well, those attorneys do.
Yeah.
Anyway, the U.S. Supreme Court's hearing oral arguments in a pair of cases which will open the door to allow the court to re-examine the now famous and infamous Section 230 of the Communications Decency Act, which was passed into law by Congress 27 years ago, back in 1996. There are a crucial 26 words from Sector 230 of that law that are what enable our Internet's media companies to remain unresponsible, and some would say irresponsible, for the content that their users post online for consumption by others. Those 26 words are, quote, "No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider," unquote. 26 words. And they mean this, essentially, this blanket protection provides that none of today's media companies, the way this has been used to thwart any attempts at civil liability, is none of today's media companies can be held responsible for the content that's being served by their technologies. Thus, it serves as powerful and what has now become crucial protection for them. But many wonder whether it might have been taken too far. The specific question that the cases address focuses upon the content promotion algorithms used by Google, for example, for YouTube, and also Facebook, Twitter, and others, to provide their users with, more relevant content. So the question may be whether our social media companies have actually crossed the line to become publishers of this content the moment they involve themselves in that content's deliberate selection and promotion, even if that involvement is entirely algorithmic. The argument then is that they're no longer acting as passive repositories of user-provided content, and that the selections made by their algorithms are ultimately motivated by profit. There's a cybersecurity law professor, Jeff Kosseff. He's with the U.S. Naval Academy, who wrote an entire book on Section 230 titled "The 26 Words That Created the Internet." And in some reporting by the Washington Post early last October, which is when the Supreme Court decided that they would hear the two cases, which are now before them, and for which they're now hearing these oral arguments today and tomorrow. Tomorrow is about Twitter. Today is about Google and YouTube. They quoted Professor Kosseff saying, "The entire scope of Section 230 could be at stake depending on what the Supreme Court wants to do. And, although the stakes could not be much higher, the way these things go, we won't have a decision anytime soon, probably not till way later in the year, like toward the end of the year at the earliest. But this will certainly be one to watch." And for their part, the plaintiffs' attorneys say that applying the sweeping civil immunities created by Section 230 to algorithmic recommendations incentivizes the promotion of harmful content, and that Section 230 denies the victims of such content any opportunity to seek redress when they can show those recommendations caused injuries or even death. So this will be very interesting. And I forgot, Leo, where you come down on 230.
Oh, well, let me put it this way. You like the chat room? You like the Discord? You like your forums? You like our forums? You like our Mastodon? If 230 is overthrown, all of those go away.
The end of the world as we know it.
Yeah, all of them go away, because right now I can't and you can't be sued for anything anybody posts on those forums. Even if it's defamatory or whatever, they're liable for it, not you, which is reasonable, right? Furthermore, thanks to Section 230, if you take something down on your forums, and because it's, racist hate speech, that person can't sue you either. And that's really important. It's the right both to publish and to moderate and not be liable. And because it's codified into law that way, you don't even have to go to court. The judge would immediately say, no, I'm sorry, that he's protected by 230. So
Right.
if they strike it down or even weaken it in any way, it's not Google and Facebook and Twitter who are going to suffer. They can defend themselves. They have lawyers by the fistful. It's you and me.
We're glad that the Supreme Court has a conservative bias at this point in time.
Well,
right?
They don't have a conservative bias. That's a misnomer. They're not originalist. Really? They just make up whatever they want and then find something to justify it. I would be much happier if they were. Yeah, but remember, this is a 1996 law. Ron Wyden wrote it, and he was very, very smart guy. And it was while they were passing the Communications Decency Act, he said, this could really screw up the internet. We need to provide, a safe harbor.
Protection.
Yeah. And so it's very, very important to the internet. You quoted the exact right book. Jeff Kossoff's book is often referred to on This Week in Google. Jeff Jarvis is a big fan of it. I've read it. It's a very, very good book, and you read it and understand it. I listened to the arguments this morning. And you never can tell with the oral arguments in front of the Supreme Court because justices will sometimes play devil's advocate. Their actual opinions aren't always on display. But I was pretty encouraged by the questions they asked the counsel for the plaintiff. And I think they get how important it is. One of the justices even said, this could have a real impact on the economy. And then Justice Kagan, who I love and was very funny, said, you don't have the smartest internet brain sitting in front of you right here, so you better explain this to us. It was good.
So why did they even choose to take it up last October?
They could have let the Ninth Court decision stand because it upheld the Section 230 rights.
Right.
It was appealed, and you're right. That's the question: is why did they take it up? And I think, there probably is some reasonable discussion around this. What they're really battling over is not so much the right to publish or the right to moderate, but whether a recommendation algorithm is in some way now editorializing. And at first, I'll be honest with you, when I first read the facts of the case, I said, well, that's actually a good point. In a way, Google's algorithm is choosing what to show. Isn't that Google creating content? But I've since seen the light and been persuaded by a lot of smarter people than I, including Kathy Gellis from TechDirt, who we're trying to get on the show tomorrow. She wrote an amicus brief for this. They also allowed multiple anonymous Reddit moderators to file an amicus brief, as did the EFF. Unfortunately, both the White House and the right, Josh Hawley and Ted Cruz, want this to be struck down for different reasons, But the wiser heads point out that it's all algorithmic. If you have a search engine and you go to the search engine, what's on top of the search, unless it's completely chronological, is algorithmic.
It's the only reason that we all switched to Google,
Exactly.
away from Alta Vista when Google appeared.
And the Reddit moderators say, no, we use algorithms to help us moderate. Algorithms aren't inherently bad. You might have an algorithm that's optimizing for profit that as a result surfaces more controversial videos, but that's not the same thing as writing an article saying, I think ISIS is fantastic. It's right. And so it's very risky, and I certainly hope the judges don't do this to slowly pare away at 230. It's only, as you say, it's only 26 words.
Right, and it is black and white at the moment.
It's very clear. It's, I think, one of the best written laws ever. It's kind of like a constitutional amendment. It's precise. It's broad enough to have lasted 20 years, 30 years, but at the same time, it's clear, and I think its intent is clear, and I'm hoping that the court does not override what was clearly the intent of Congress when they wrote that law.
Yeah.
So let's cross your fingers. I don't know if they're conservative, but let's hope they make the right choice.
Hey, I'm Rod Pyle, editor-in-chief of Ad Astra Magazine, and each week I join with my co-host to bring you This Week in Space, the latest and greatest news from the final frontier. We talk to NASA chiefs, space scientists, engineers, educators, and artists, and sometimes we just shoot the breeze over what's hot and what's not in space, books, and TV. And we do it all for you, our fellow true believers. So whether you're an armchair adventurer or waiting for your turn to grab a slot in Elon's Mars rocket, join us on This Week in Space and be part of the greatest adventure of all time.